made that reference in order to suggest that perhaps there is some other law that enables 36 to be put out of court. Well, my lords, our ground is that your lordship's decision respectfully was per incuriam of section 26. It's not as if your lordships adverted to section 26 and then said that because of some other law we are not going to apply. That's not what happened. Your lordship didn't advert to it. Now, and it's quite clear in their opposition. It's quite clear that that's what happened, because they then tried to use your lordship's ruling on the 16th of February. They tried to use that.
My lords, we have not tried to use that. So my counsel should not refer in responding to my submissions that they have used it. We have not made any such reference in our affidavit.
There's such a unity of purpose.
There isn't. We are different parties.
And my lord, my only other point by way of response is that counsel for the first respondent asks, what reliance did we place on the depositions that were made? Evidently, we relied on that to close our case, as we did. Because, my lords,
is it a point of law?
I'm sorry.
Is it a point of law?
I'm sorry.
Is it a point of law?
Is it a point of law?
Yeah, what you want to respond
well,
to?
My lords, the issue was raised whether we had relied on it. That's a point of law, whether they had been relying, because they're saying that
it's a matter of fact.
It's a matter of fact.
It's not.
I think, my lords, so my lords, on what evidence are your lordship going to? No, on what evidence are your lordship?
Order.
Respectfully, then the question on what evidence are your lordships going to determine that matter of fact? My lord, respectfully, this, I think, is an appropriate situation where it's really a mixed question. It's a mixed law, in fact, because he is saying that legally, the reliance on the deposition is part of what kicks in section 26. And my point is that, yes, in reliance on that deposition, we close our case. And we made that evidently clear in this court, because
so you've made this point. Their view is that you did not rely on it because you pursued those applications. Your view is that you relied on it, and it's on that basis that you closed the case. So we have heard both of you.
It is not just my view, because the question whether we relied on it really lies within our courts, much more than their speculation, because nobody can speculate in terms of the conduct of our case. The conduct of our case, as we had it, relied on, because when you come to court, you rely on what comes to you from the other side as well. So, my lords, we clearly relied on that conduct, and our main submission on that section 26 is that your lordships did not advert to that, much less try to
you realize
qualify.
that you did not, in your submission on that day, you never referred to section 26. On your submission, during your submission.
My lord, on that day, your lordship asked me, is it an estoppel argument?
No,
and I said, yes.
No, that was the answer. You did not refer to as section 26. Section 26 had come into play in these proceedings during the last argument. That was when you relied on, because I've looked at the proceedings of the 9th February.
Yes, my lord, I did not refer to section 26 on that occasion because, my lords, the question about estoppel, your lordship asked me, and I said, yes, it was estoppel I did not refer to Section 26, but that's a matter of...
The question about Estopel was asked during the last...
Note, your lordship asked me the question about Estopel during the transfer.
That is what caused you to write to us, that you needed to give further submissions.
No, my lords, respectfully, my lords, no, that is not, respectfully, that is not the case. The transcripts are very clear, respectfully. My lords,
I have a question.
yes.
I have a question. My question is, these affidavits, were they not sworn to before the trial, before the hearing? They were sworn to during the interlocutory application.
My lords, affidavits sworn to during...
No, I'm just asking a question. Were they not sworn to before you put your witnesses in for hearing?
Yes, they were.
Thank you.
And my lords, that has no significance for the reliance. It has no significance for the reliance that we placed on it in the conduct of our case. Because your lordships will...
I'm satisfied with your answer.
Well, you can't be satisfied with your answer.
Order.
Yes.
Order, please.
My lord, you can't be satisfied when I have not completed my answer.
Order in court, please.
I've not completed my answer, and your lordship says I'm satisfied with your answer. You're cutting me short in giving an answer that will address what underlies your question, because what underlies your... If my lady can allow me...
Just a minute. Respectfully, Mr. Chikata, these are matters of fact. The date on which the affidavits were filed, the date on which the trial was conducted, these are matters of fact. So I could even come to that, I could do that evaluation without asking you a question. I chose to ask you the question so that you could avert your mind and confirm. That is all.
Yes, but
so in answering my question...
So may I complete my answer?
Very well, Mr.
Because, my lord, when affidavits are sworn to in interlocutory proceedings, in the course of a trial, it is open, for instance, to put the matters that were deposed to in an affidavit in an interlocutory proceeding to the witness when he enters the witness box, and to put before them, didn't you say this on oath in an affidavit before this court? This is a matter that is quite basic in the practice that I'm familiar with, that when you have an affidavit sworn on oath in interlocutory proceedings, and a witness comes into the witness box to testify, that affidavit can always be put to them in terms of the veracity of the things that they say. So you can't say that just because this was done in the course of interlocutory proceedings that were before the trial itself, they have no bearing on the conduct of our case. Because my lord will recall, my lady will recall, that this whole matter of crossing that bridge when we get there was in terms of whether cross-examination would provide an opportunity for those matters to be addressed. And your lordships, one or two of your ladyships, put across the perspective that shouldn't we be waiting until cross-examination before we address those matters? And indeed, that is precisely what we did, because your lordships ruled against us, so we had to wait for the cross-examination to take place. And we waited on the basis of sworn affidavits by the chairperson of the first respondent.
Please, the court will rise to consider its ruling.
All right.
And the court is done here in the arguments from the petitioner's side, and the two respondents in this case on this review application. A reconstituted panel of 9, they've heard this matter of a review. Mr. Chikata has been arguing he wants the Supreme Court to depart from its earlier decision that essentially said that the second respondent in this petition, which is the Electoral Commission, can choose not to have its witness in the box to be cross-examined. That was the decision by the Supreme Court on the 11th of February. Now, Mr. Chikata has argued his case out. He wants the court to depart from that decision. Whether or not they would arrive at that conclusion, we will see in a bit. The justices are now going to consider and come back to the court with a decision. It's our election petition 2020 update is proudly in association with Petrosol, DBS Roofing, and Koa Mixture. My name is Mama Vioso Abuade here with Daniel Dazi. We will be reminding you of the arguments from the petitioner's side and the responses, the counter argument, if you like, from the two respondents in this matter. The first one, the Electoral Commission, and the second respondent, Mr. Kufuado, in this case. There were some issues that also came up. Remember that Peter McMenu, the NPP's Peter McMenu is the one who we've been told several times who has the power of attorney from the second respondent in this matter, representing him in court. There was a bit about a justification why he has the power of attorney. Let's get, first of all, some kind of understanding with the legal issues that have come up in court today and the processes where we are. Mr. Martin Pibble is a lawyer. We're happy that you've joined us. A very good afternoon to you. Thank you so much for your time. This is a review application, of course, for the court to depart from its earlier decision. We know that it's usually a special jurisdiction in terms of the review. It's not a place that they often go, and we've seen in an earlier ruling with the interrogatories, a similar one where all 9 justices dismissed the application. So first of all, remind us again, what do the petitioners have to do differently as we've seen them do in court today? What do they have to do in order to get the Supreme Court to depart from its earlier decision?
Barabi, that because the court is yet to give a ruling, this will be court if I were to proffer a different opinion that this is lacking, that is not clear and all that. So rather, I'll stick to the law. What does the law say should be done in order to get a review in a party's favor? A party who is satisfied with the ruling and who decides to go for a review. What is the hurdle to be crossed? So that on the face of the law, it says that it has to be exceptional circumstances. Exceptional circumstances. And some of these exceptional circumstances could be, that's one leg. The other one, saying that there's a miscarriage of justice. Okay? So the exceptional circumstances, so if you can say that maybe there was a law between, naturally, because we are human beings, we are bound to make mistakes. You can prove that there is a very critical law that the court didn't see, the court didn't apply, the court didn't have made its mind to. Yes, and it's not even that one, because it's not a law. Sometimes you go, they say that no, this is not sufficient. This cannot tilt the scale in your favor. I mean, there is a decision where the decision stated that look, the fact that we even made a mistake, it's not sufficient to overturn the decision. So his view is a very high to the start, very high hurdle. It's not, there's no stress. I mean, you say, so the circumstances to which it is granted and those to which it is refused, we can only say that it depends on the judges. You say, yes, because it is not likely that. As I've stated, there's one situation where you get Justice Dr. Datiba, he said, look, the fact that we made even a mistake doesn't mean that we are bound to issue the decision in your favor. That's one of the things of decision. So that is it. Based upon the way the law is drafted, it's very high hurdle to cross. So if you look at the injustice of it, cases go one way or the other. One party wins, the other loses. So you won't be able to make that if I deserve to win because justice demands to.
Mr. Pebo, I would appreciate it if you could just reposition yourself. We're experiencing some breaks in the line there. Hello, Martin Pebo?
Yes, I can hear you.
Okay, yes, sir. Yes, it is. Okay, so just, at the beginning of today's hearing, the parties were allocated some 30-minute standard time for arguments with room for extra time. Indeed, Mr. Chikata did get some extra time. And this was for case management purposes, the Chief Justice explained. So they are mindful of the time. I want to ask you, earlier, what was scheduled to happen today was the hearing of highlights of the parties' written addresses. They would come back and give their ruling on this current matter. But what are your expectations? In the morning, I had a conversation with a person who is with the petitioner's team, who is also Director Legal Affairs with the NDC, Mr. Abraham Amaliba, who indicated that they had not filed the written addresses. The court gave an order, but because of their two applications at the time pending, they had not complied with that order. Is that standard practice?
Oh, no. So the last time such a matter came up, we all even learned because there was a recent Supreme Court decision that even for some of us, it hadn't come to our attention, okay? But through this petition, we saw it. That's the case of the Parry versus High Court, Tamale, ex-party Henry Kalim. And the Supreme Court made it clear that when a person applies for stay of proceedings, the application alone is not sufficient for the person to stop doing what he has been ordered to do. So if there's an order that file addresses, it means that do it to the best of your ability. And when the application comes, the court will look and see whether really they will grant the stay or not. So you remember the last time that this matter came up in the election petition, the judges admonished the petitioners to make sure that they adhere to or comply with the court orders. Do you remember?
Yes.
Yes. So that's still the same law, except that, because the Supreme Court also does substantial justice, they can look at it and say, okay, look, on this occasion, we will waive that requirement. All of it is for the court to determine. But if we're talking about on the face of the law, the applicable principle is that once an order has been made, comply with it. Even if not fully, at least you must be seen to have made an attempt. So if, let's say, you even want to write 300 feet, but because they had to spend time mounting the two other applications, they could do just 100. Yes, you indicate in all that. And then you say that subsequently, depending on how the application for stay goes, you will seek permission to complete the addresses. Then that way, it's middle of the road. I'm sure the justices will understand. But when the order has not been totally complied with, there's nothing in terms of complying, then even Rule 79 of the Supreme Court rules itself even says that the court can stop all the proceedings until the party has complied. But as I've said, beyond all of this, then there is also the overriding principle of the justice of the king. The court can look at it and say, look, this time we will waive. So there's also that same 79 says that, but the court has power to waive. The court has power to waive. So when we get to that motion, we will see whether on this occasion the court is exercising its discretion to waive or to come down hard on the petitioner.
a lot of bridges in this case, Mr. Martin Pebble. We will get to that bridge when we cross it. We will get in touch with you again for some legal explanations. Martin Pebble is a lawyer. He joined us with some understanding. It's your election petition updates here on Joy News. Court's taking a break. They're going to be deliberating on that argument that he just heard. It's an application for a review of an earlier decision, a decision that a party, if a party chooses, elect not to adduce evidence, that's the party's sole decision. They can choose to do that, and you cannot force a party to put its witness in the witness box to be cross-examined. That is where we are with this election petition 2020. Daniel Dassey is here.
Hi, Mamavi. I think this is a beautiful exhibition of, our democracy at work. Our justice system is really taking the center stage now. I can't wait to hear the decision that the judges come up with. Absolutely.
Well, stay with us. We're taking a breather. We will be back to remind you again of where we are with this election petition. But it's proudly brought to you by Petrosol. Also, DBS Roofing and Koa Mixture. We'll be back with some more updates on the election petition. We thank you for staying with our election petition update here on Joy News. And it's in proud association with Petrosol, also DBS Roofing and Koa Mixture. My name is Mamavi Oswabuaje here with my colleague Daniel Dassey. We've just heard arguments being made for the Supreme Court panel of 9 to depart from an earlier decision on the 11th of February that said that a party could not be compelled to put its witness in the witness box. Mr. Chachichikata, who is lead lawyer for the petitioner, made his argument. We also had arguments against this application from the 2 respondents also in this matter. Just to remind you, the grounds under which Mr. Chikata is making this case, seeking the review, is that, and this is 5 grounds, and the arguments that he essentially makes in court today is around these 5 grounds. One is that the ruling of the court in respect of the Electoral Commission not being called to testify was per incurium section 26 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice to the applicant. Let's get on the phone lines and speak to lawyer Samson Ladi Ayenini. Samson, really appreciate that you could join us on our election petition update. I just wanted to ask you the 2 key grounds that a person must satisfy, I beg your pardon, for the court to review an earlier decision, is that there must be exceptional circumstances which have resulted in miscarriage of justice. Are we saying here that the justices themselves must realize, after they go through this second phase, that they made a mistake in law in their earlier decision?
Judicial decision making is a process involving human beings, and that's provision by the framers or the makers of the rules. CI 16, that is the Supreme Court Rules 1996, is a clear acknowledgement of human error. And so, as you know, at every stage of the judicial process, something can go wrong, and there's an opportunity to correct by going up further. There are certain things that the court is allowed to correct by itself without you having to go up further. there is a review jurisdiction within the superior court, as in the high court, for example, where a court would have made an error, patent on the face, but it's a human institution, and you just go back to the same judge and point it to them. They are human, so they would have made a mistake, they will acknowledge the mistake, and they will make a correction. I did one of that very recently, and the judge was very excited about what I had done, and because of that position I urged on the judge, someone else who has suffered a similar situation was called from custody and brought and set free because a wrong position had been used to occasion an injustice to the person, and the person was in jail. But because it happened to my client, and I took the view that I know beyond that point, okay? It's good as lawyers to know the general position, but it's best to also know the exception. So I went back to the court and argued before the same judge. And the judge was so very happy and said, yes, I made a mistake. I made a wrong. What you have shown me, clearly I was wrong. So your client should be released. And I had used the same principle against another person, the person should go. Now, if you look at the system, from one stage to the next, there is the opportunity of correction. That's to admit human error, our humanity. It's the same thing that you find in the Supreme Court. But once it gets to the Supreme Court, the threshold must be a lot higher. And that's what you find in the Supreme Court. That is the last court. After that place, you can't go anywhere else as far as the judicial system is concerned. And yet they found reason to allow for an opportunity for a review within the apex court, whose decision is final. So if that must happen, then they must circumscribe the grounds under which you can come for a review. That's why they say in the rules that you can come under grounds, including the one you just mentioned, which is the first. The second is a discovery of new and important matter or evidence, which, after the exercise of due diligence, was not within the person's knowledge or could not have been produced by him at the time when the decision was given. So, the first position, exceptional circumstance, which has resulted in a miscarriage of justice. So you are not only talking about something that has led to a miscarriage of justice, but clearly circumscribed, exceptional. So you must show the exceptionality of the circumstance and then proceed further to show that because of that, there has been a miscarriage of justice. Then round two, either you have discovered a new or important matter or evidence. Not just having discovered it, but the fact that at the time the court was doing its job, at the time you appeared before the court for the court to do the job, you had exercised due diligence, and yet you couldn't find it. Or that it could not have come within your knowledge, or was not produced at the time, even despite due diligence and so on and so forth. So it's a very narrow gate. It's like the gate to heaven. It's narrow, it's not broad.
Samson, we see that there are two justices who have been added to the panel, obviously because it's a review application. But what can you tell us? Justice Tanko Amadu was on an earlier panel, a similar panel with the interrogatories review. This time around, we didn't see Professor Henrietta Mensah-Bonsu return with him, but there is Justice Averill Lovelace Johnson. Tell us about these two justices, if you may.
Okay. So these are very experienced judges who have spent some considerable time within the justice system. Umaru, Isifu Umaru, I normally say Umaru, it's supposed to be Umoro.
Umoro, yes.
Isifu Umoro Tanko Amadu. He spent quite a lot of time at the High Court, and you may have heard me mention before that as law students, we were instructed to identify his court. And when we had time, we had to go and sit in his courtroom because he is your master of the rules, and he manages his court in a way that you can learn, and lawyers like to go there to learn. So there were even times that people go to court. Maybe you have one or two cases and you are done, and you don't have any other case to do until a certain time that you want to leave the court premises. Then you go in there, just sit and follow what is going on. There are a number of judges like that whose court lawyers and law students like to go and sit in. Now, so he's been known to be a master of the rules to a great extent, and known to have, his law very solid. So it's interesting to see him back. He was on the panel the last time there was a review, together with Professor Justice
Henrietta Mensah-Bonsu.
Henrietta Mensah-Bonsu, our favorite teacher again. So I don't know why she was not. She didn't join to return, but there's nothing about that. There's no issue about that. As far as there's a pool of judges who can be called upon to come, it's fine. And Lovely Johnson also, certainly. So I'm looking forward to see Justice Tanko, if you like, pair with Justice Samuel Manfo-Style, who also is your master of the rules, if you like. He's actually authored on the rules, and we read him on the rules, how the rules apply. So with these two in there, you are likely to see them, pointing to the rules to their colleagues and insisting on whether or not the threshold that has to be met in the section, the first section in CI 16.
Rule 54?
54, the review grounds, whether they have been met or not. You may have those as the ones who will be pointing their colleagues to those particular portions. Well, the Chief Justice himself has also been a supervisor of civil procedure process, and has actually taught it also in the law school. So sometimes people may use that to appreciate their background, that they sort of like to stick to the rules, as it were, and don't want to give in too much room. But, a lot of things goes into a judge's mind in determining an issue. There are jurisprudential theories that this platform will not allow us to discuss.
Samson, there was an issue that one of the justices raised, wanting the lead counsel for the second respondent to justify why Peter McMenu has the power of attorney of the respondents.
And yet, one of the lawyers was the one who deposed to the affidavit, right?
Correct.
Right.
Can you?
So, as a matter of practice, as lawyers, if you instructed me to do a case for you, the originating process will definitely be in your name. If it is a writ, I'm the lawyer who will sign off on it. But if the originating process was a petition, if it was an affidavit, then you, the party, not the lawyer, will be required to sign on it. But in the course of things, in practice, it's allowed for lawyers to depose on affidavit on behalf of their client. But oftentimes, we prefer where we will do it for you anyway. We will explain every line, except whatever goes in our mind in the affidavit to you as our client, and then you have a full understanding and you sign it as you, the party, or somebody else that you would have given a power of attorney to represent you. We will let them do so. But as a matter of practice, there is no law that, is signed against. If the lawyer, or even many times you would see that the affidavit may have been sworn by a clerk in the law firm or some other officer in the law firm. But for some lawyers, including myself, as a rule of thumb, I will only make, a staff of the firm, take instructions from the client and then sign the affidavit only when the client is practically unavailable. Otherwise, I prefer for the client to be the ones to sign their own affidavit, because once you put the affidavit in court, issues can come out of them. And when the issues come, it is the one that has sworn to the affidavit that will be called upon to answer or to be subjected to cross-examination. So as a rule of thumb, I think a good number of lawyers, maybe not too many, but I suppose that would be the case, just like myself, I'll prefer that the person who will be called upon, if they have to be cross-examined, should be the one to sign the affidavit. But there's no rule that is signed against, as far as I know, if the lawyer does it. And lawyers have been doing it as a matter of practice, because you have been instructed. And I have known some judges, like Justice Anthony Yeboah of blessed memory, who used to say, for example, that he didn't see the point where some other judges will insist that, okay, a case has been called. Where is the client? He says, well, but that is why the lawyer is here. The lawyer is pleased to represent the client and to do their job. For as long as we do not require, we are not at a stage where the party will go into the box to speak, he doesn't see why you should require that the party should be attending court. So some of us take that also and ensure that if you are doing a case, unless you get to a stage where it's not technical issues you are doing in court, where your client is not needed, you let them relax. And then when they are actually needed, you bring them in. But when they are available, it is good for you to let them come in all the time so that they will consume the process. And then you'll be on the same wavelength, so to speak. So there's no rule that is suspended, as far as I know.
So was he generally drawing lawyers' attention to something? Was there something for you to learn, for instance?
Yes. Justice Amegacha has taught, us in the law school, together with Samuel Kujeto. They used to teach the subject of ethics, and they would say, like I have said earlier, that better to do it this way than to put yourself in there. Because if issues came up and cross-examination had to happen, you, the one who deposed to the affidavit, you step in the witness box. And you can imagine that you, the lawyer conducting the case, you are now going to have to step into the witness box. Can you imagine how it looks like? Either the dock or the box. We say the witness box when it is a civil matter, and when it's a criminal matter, you get into the dock. So that's it. But even in criminal cases, the law allows us, in certain circumstances, for the lawyer to make all the representations that have to be made for the client. So it happens, yeah. But I think he's bringing what he teaches to this platform so that some of us who may have forgotten may be reminded that it's always good to do it this way.
Okay. Finally, something, there are a number of decisions that have gone against the petitioner. The interrogatories plus the review, admission of facts, inspection of documents, the very recent one, which was an application to reopen the petitioner's case, that the application was also dismissed. Does these rulings matter?
Of course, they matter. They must matter, because if they didn't go the way they went, perhaps maybe now we would have been going through a certain smooth process rather than, applications upon application. But I think we must all appreciate something, and particularly because this is being broadcast to the whole world, and people without legal lives and training, are trying to consume, have a difficulty particularly appreciating how some of the things are going on. I like to tell them that, these are normal things we do every day in the courtroom, except that this, of course, is a different matter, so to speak, because it is a political case. And it's not just any political case, but it is about the presidency and elections. So the stakes are high. Nonetheless, you see, if the rule is this, it will be applied. So if you find them, and I hear people say unanimous, all the time unanimous, all the time unanimous, why can't we have somebody disagree? So from a purely technical point of analysis, legal technical point of analysis, it is possible to say that you find the rulings unanimous because the positions of the judges are the same as a result of the law the laws that are invoked on those matters. So the laws that are invoked for each of those applications have a certain expectation, and so they are all upholding that expectation. If they are dismissing a matter and they are doing it unanimous, or they are upholding something and they are holding it unanimous, the legal technical explanation you can give is what I am giving here. That's because you, Mama V, myself, or Kojoyan Singh, or somebody, we have been put together as a panel. And there is a rule that we are supposed to use to determine the issues that will come. We know the rules. And when the issues were brought before us, we applied the rule. When we applied the rule, it led us to one conclusion. Therefore, we were unanimous. But I will admit to you that on 2 occasions, I had expectation that while this is the standard general position of the law, I felt that because it is the apex court and it's not bound by any precedent, and it is the creator of the precedent properly, so to speak, there were at least 2 occasions where I had a certain feeling that if they were not unanimous against a matter, in upholding or dismissing a matter, at least there would be 1 or 2 who would have dissented, and that happens in the court. They would have dissented to say, well, I disagree with the majority, or that's it. So, and they will give a reason and say, while this is the standard, while this is what is known from precedents, from things whenever, I think that we have an occasion where we are able to make an exception. But you see, the difficulty has to be, they must ask themselves the question, if we are making an exception, will that exception bring judicial internal coherence so that it will not disturb a certain settled principle in a manner that is not good going into the future.
Okay.
So they will ask themselves all of these questions as they go into the right now. Because judicial philosophy, they'll be thinking, they'll be asking themselves, okay, we have ruled this way on this, we have ruled that way on this. Now we are being invited to come this way. Can we ask ourselves which decision will bring judicial internal coherence in the law?
Okay.
So that you don't unnecessarily vex the law in a matter that disorganizes the system.
Okay. Well, Samson, really appreciate your time. Thank you for the explanations. Samson Ladi Ayenini there. Let's go to the courts now. Kweku Asante is my colleague there. He will tell us what's happening. Kweku, I know that the judges normally won't tell us how long their deliberations would take, but maybe the registrar has said something in court. Do you know when the judges will be back? Yes, hi, Kweku. If you can hear me, I'm asking, do you know, have you heard about when the justices will return with a decision?
Like you mentioned early on, usually when the court rises to consider a matter, they do not tell how long they will take before they come. But it is anticipated that this will take a while before they return, because you look at previous cases and the judges actually took an adjournment to render judgment or render their ruling on another day other than the specific day the case was argued. And so it's expected that maybe this will take probably some time before the judges will come back to render their ruling on this review application before the court. But I mean, not to to preach to the converted, the two new judges who have joined the panel are Justices Amadou Tanko and Lovelace Everett-Johnson, who have joined the panel to adjudicate this specific review application before the court. Listeners and viewers may recall that Justice Amadou Tanko was part of the first review application that was sent by the petitioner on the interrogatories together with Professor Henrietta Mensah-Bonsu. He has returned and he's been joined by Lovelace Everett-Johnson. And so counsels for both the petitioner and the first and second respondents have made submissions at length for and against the specific review application before the court. Mr. Chachujikata, who was initially given a 30-minute time to make his oral submission, ended up doing some arguments close to 1 hour with Mr. Kotuampao and Justice Mr. Kotuampao and Mr. Amenuvo coming in with very few minutes to, as it were, make their arguments against the review application. And so, according to Mr. Chachujikata, the court earlier ruling was delivered per incuriam to say that it had no basis in law, and so it is asking the court to vacate its earlier judgment. And some questions came from the bench, particularly from Justice Gertrude Tekuno, that to try and solicit information from Mr. Chachujikata on whether or not this was simply trying to re-argue the earlier case which had been thrown away, or this was pointing out specific matters of law that he thinks that the court did not avail their mind to in delivering their earlier judgment. And so that was actually the anchor upon which the first and second respondents made their argument, that the petitioner is simply trying to use the back door to re-argue his case, and that the petitioner has not raised specific legal issues with the judgment that was vacated, and said, Mr. Kotuampao particularly referenced some of the arguments that were made by Mr. Chachujikata, and actually said that all those arguments had been made in the original application before the court, and so that there was nothing for the court to consider now. But they also went ahead to respond to a few issues that Mr. Chachujikata had raised. And so Mr. Chachujikata says that the Smaila Bill decision that the court cited in its judgment, that the ratio, that the reasoning behind the judgment was not properly applied in this specific judgment, and was the court to avail their mind to some of those issues that he has raised. And so we are waiting for the court. Like I told you, the inkling we have here at the Supreme Court is that this will take quite a while, because like I referenced, sometimes when some of these decisions are taken, the court takes an adjournment to come to try and decide on this matter. But now that the court is seeking to do so right away, it may take a while. But barring this application for review before the court, today, the counsels for both the petitioner and first and second respondents would have made their closing arguments. Their written submitting addresses would have been submitted to the court already, and they would have made oral arguments on those documents. But because of this application before the court, that was not heard. There are even those of us here who are expecting that the court will probably rule on this application and then proceed to deal with the closing arguments and then set a day for judgment. And so those are all open. Those options are all open for the Supreme Court judges who are sitting on this case, and we are waiting with bated breath to see exactly what the judgment or the ruling in this application for review will be. Mama V.
Okay, Kweku, tell us about the mood in courts.
Right, so as usual, there is very heavy security here, and the lawyers for both the first and second respondents are not given so much of an inkling in terms of what they make of the review, aside the arguments that they've made before the court. But there's also some of the things that happen in court that people who watch or listen from their homes or wherever do not pay attention. That is the body language in the court, as well as the body language.
Well, I have to apologize for the breaks that we're experiencing in the connection there. Kweku Asante is my colleague reporting from the Supreme Court for us on the processes today. Kweku, we lost you quite a bit, but you're telling us about the things that we don't see. That's the kind of posturing, if you like, from the people in the courtroom. Continue.
Right, and so these kind of posturings, because the cameras are not allowed to zoom into the judges and also to zoom into other parts of the court, viewers and listeners may not be able to pay attention to some of these things. But when Mr. Chachuchikata was making his argument, you could sense from the first and second respondents' side of the court that they thought that this was simply trying to re-argue the case, with people shrugging and people passing notes for Mr. Akoto Ampaw and Mr. Amenuvo to come in to argue. Of course, the argument for against the application for review that was made by Mr. Amenuvo in particular was very short, as well as that which was made by Mr. Akoto Ampaw, also very short, because like I told you earlier on, the contention of the first and second respondents is that there's actually the review, the bar for review has not been met by the petitioner, and so they are contending that the review has not been properly placed before the court. But of course, they went ahead to make some arguments to respond to some of these things. So here in court, you could sense that both sides are quite confident about the cases they put before the court. Of course, at the same time, trying to disregard some of these arguments that have been made by both sides of the aisle. But the judges now has the ball in their court to make a decision on whether or not Mrs. Jane Mensah, I beg your pardon, Ms. Jane Mensah Adukwe, the returning officer of the 2020 election and the chairperson of the Electoral Commission, the first respondent, can be compelled or for whatever reason can be made to come and sit in the box and answer questions and a cross-examination from Mr. Chachuchikata as he's argued at length.
Okay. Kweku Asante, thank you very much. Kweku is a reporter at the Supreme Court today. He will be back with a lot more after this ruling is delivered. Kweku, thank you very much. It is still your election petition update in association with Petrosol, DBS Roofing and Kwa Mixture. The court just heard that application for the court to depart from its earlier decision. The arguments by lead counsel for the petitioner, Chachuchikata, and then there were also arguments by the two respondents in this case, the two lawyers, Justin Amenuvo and Akoto Ampaw. And court is taking a break to come back with a decision on this particular application. It's a review application, but the court had earlier scheduled that today they would hear highlights of those written addresses that it ordered the parties to file by close of day yesterday, Wednesday. So we wait to see what happens next after this ruling. But we know that there are all the decisions so far out of this 2020 petition has been unanimous. There was a unanimous decision to get the petitioner to correct some mistakes in the petition that was very early in this process. Subsequently, there were unanimous decisions. One on the interrogatories, those 12 questions that the petitioner wanted the chairperson of the Electoral Commission to respond to. Unanimously, the panel dismissed that application. There was also admission of facts, inspection of documents. The very recent one was to reopen the case after the petitioner's lead lawyer announced to the court after its third witness was cross-examined that they had closed the case. That application was also unanimously dismissed. This will be the second time that the petitioner has come for a review, because it also went for a review on the interrogatories decision. This is the second time. We will see what the court says. They've reconstituted the panel. There are 2 additional justices on this particular case because it is a review application. After the court delivers its ruling, we will see the 2 leave the panel. We will remain with the original 7-member panel to continue with the rest of the hearing. Stay with us. It's your election petition update. We'll be back shortly. This is your election petition updates, brought to you in association with Petrosol. Clean fuel in full quantity is always a delightful experience. Now, due to hard times, we have become value hunters. But are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart. Hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us, Petrosol clean fuel in full quantity. Our broadcast is also in association with DBS. After several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of ColorLink Plus roofing sheets, which means ColorLink Plus roofing sheets always stay clean and beautiful for you. It's been 26 years in the making. They're also giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra. They're on the Spintex Road in the DBS Roofing near Papaya Restaurants. Give them a call. Here are their numbers: 024 0844444 or 054 3286 637, or visit their factories in Kumasi, Tamale, and Takoradi. DBS Industries Limited, we truly are your roof experts. And our update is also in association with Koa Mixture. It's the immune booster for your general well-being. Well, if you've just joined us, this is the election petition updates. We've heard arguments go on in courts. We want to bring you excerpts of it.
Order 38, Rule 3E1 of CI 47, as amended by CI 87. Now, my lords, Rule 38 3E5 what was relied on by counsel for the first respondent initially. Now, in the course of my submission, reference was made to Rule 38(3)(e)(1). Now, this does not appear to be denied in the submissions of respondents. What they appear to be saying is that 3(e)(1) is a matter of law. And your lordships will recall that, well, I shouldn't say your lordships will recall, because this is a bench that is different from the bench before whom we made the initial arguments. But, my lords, in respect of 38(3)(e)(1), the reference to that order was first from the bench. And the response that I gave...
Well, apologies, we have to cut through this and take you back to the Supreme Court now.
Counsel submitted that this court in the ruling and the review failed to consider. We have considered the submission on the effect of Section 26 of NRCD 323. We are not persuaded that the issue of statutory estoppel urged on us by the applicant's counsel by reason of not specifically referred to in the ruling and the review renders the ruling per incuriam. We have also taken into consideration the applicant's reliance on Article 19, Clause 13, and 296 of the 1992 Constitution. Yes. We are of the view that the applicant has failed to satisfy the court that new or important matter resulted from the reference to the constitutional provisions referred to. In the result, the application fails and it is hereby dismissed.
My lords, we are most grateful. And as I intimated, I think that this is an occasion where the respondents
it is a constitutional matter. It is. And the practice which has been settled in this court is that you don't award cost.
That is true. My lord, I'm very well aware of that. Yeah. But my lord, I think that the court should be amenable to grant costs even in constitutional matters.
Please, we won't.
When there's, I'm not talking about in this one, when there is a continuous abuse of process. I think that it should be possible. Very well. My lord, I'm grateful and advised.
We decided to set a date for judgment today. Yeah, but our attention has been drawn by the registrar to the fact that an application for review of the last ruling has been lodged at the registry, And we want it to be adjourned to Monday so that we'll come and take it on Monday. Yes. So we want, yes, Council.
Yes, my Lords, I was going to address you on that. My Lords, this court has held that the review application, a stay application, etc., they are distinct.
Yes.
So it's my humble submission that irrespective of the application that is filed, I believe that the main action will be guided by whatever the court says.
We are going to give a date for judgment, but then there is a pending application which may have some adverse whatever consequences on whatever judgment we are going through. So we are saying that we will take it on Monday and adjourn it for judgment. So Mr. Amenuvo, what's your problem?
Well, my Lord, I'll be guided.
Yes.
I'll be guided. I'm grateful.
Please, there is another motion for stay,
yes,
which was also fixed for today.
Yes.
Yeah, we will rise and come back and take the application.
Very well, my Lord.
The court will be reconstituted. Yeah.
All rise. The panel will be reconstituted.
Court has decided on the review application brought by the petitioner, and the result is that the application has failed. It has therefore been dismissed. Another unanimous decision by the court. This was a review of its 11th of February decision, which essentially said that you cannot compel a party to put its witness in the witness box to be cross-examined. Mr. Akoto Ampao there, the second respondent's lead lawyer, was pushing for costs to be awarded to the petitioner, but the Chief Justice reminded him that this was a constitutional matter and they could not award costs in this instance. He justified that by saying that there was a continuous abuse of process, but he was reminded that there had not been proof of this allegation, so no costs awarded in instances of constitutional matters. The court has also said that they were ready to set a date for judgment, but the attention has been drawn to the fact that there was another pending application, another review application, this time of their recent decision, well, before today's decision. We will take it back into the courts. It's a reconstituted panel that we will see. So the 9-member justices who sat on this review application that we've just heard the decision, which is a dismissal, another unanimous decision, will be reconstituted. We will have a 7-member panel. The original 7-member panel sits on another application, which is stay of proceedings. Samson Ladia Yenini is here, is back with us on phone. Okay, we will connect to him in a little bit. But the ruling, which was rather very short, delivered by the Chief Justice again, is that the review application by the petitioner has failed. The review application has failed, did not meet the required grounds, therefore it has failed and they have dismissed the application. There's another pending application. The court says they would return on Monday to hear that matter. That's another review that I'll tell you a little bit about, but they will return to deal with another matter today. So the session hasn't closed. We will just get the 7-member justices return, and Samson joins me via phone. Samson, there's been a ruling in the application that we heard, the arguments that we heard in court today, which is that it has failed and it has been dismissed. but the court is just about hearing another application, which is the stay of proceedings. Can you explain to us what does that mean? Initially, some people thought it was for them to deal with the review matter, but that has been dealt with. So what are we staying proceedings for?
Okay, so when you are asking for stay of proceedings, you ask for it. Because you have something pending. That's all right. That's all right.
Okay, something I have to sincerely apologize to you. We see that justices returning to take their seats. We will come back to you after.
A fifth of the babies who come in.
Lords, writ number J1/5/2021. John Dramani Mahama. This is the Electoral Commission of Ghana. Nana Ado Dankwa Akufu Ado. Mr. Samuel Fosuampofu, the petitioner. Represent the petitioner, my lords. Jane Mensah, chairperson, represents the first respondent. Mr. Peter McMonu will also represent the second respondent.
I appear for the petitioner, applicant.
If it pleases my lords, Justin Amenuvo appears for the first respondent. With me is Alexander Samoa.
If it pleases your lordships, Akoto for the second respondent. And lords, with me are my learned friends, Frank Davis, Kweku Esrifi, and Yao Pong.
My lords, we filed this application for stay on the 16th. And at the time, the application for review was pending. But more importantly, my lords, you had given orders in respect of the filing of addresses. And those orders included an order that the addresses should be filed simultaneously by Wednesday the 17th. My lords, you have the review application has been disposed of by your lordships, but in view of the fact that there were the orders that your lordship had given in respect of the filing, I believe that in this application we would have the opportunity for your lordships to provide the appropriate timeline within which we can now file the written address, because that was pending the hearing and determination of the review order. And my lords, in that connection, I would respectfully also draw your lordship's attention to the fact that in making your orders in respect of the filing, it would appear that your lordships did not advert to Order 36, Rule 4.3, which was cited before you, and your lordships may wish, therefore, to take that into consideration.
I know that
Yes.
Yes, but then the problem with the petition is that it appears to be a new beginning altogether. We have to do some cases to recognize the hearing. So we decided to have it. So we would want to come back on Monday. If you have not complied with it, yes, you can tell the court to maybe grant you some.
Okay, so yes. pending yes. The Monday's application.
No problem. No problem. That one, it is worth taking, but the order was a pending order, which had not been discharged or varied. To the extent that the application for today was filed on, I think, Tuesday or so. Yes. Mm-hmm.
My lord, I'm not there. The application for today was, I'm not able to sign.
Yeah, but when we come on Monday, we want to take the, excuse me, sir.
Very well.
When we come on Monday, we will take the application.
Very well.
And adjourn the case for judgment. Yes.
Very well.
Yes, Mr. Amenuva.
Yes, my lords, I was going to make a submission on the application for stay of proceedings.
Yes.
And my lord, my submission is that this court has held in the case of the Republic versus High Court Commercial Division.
He hasn't moved the application. He hasn't moved the application. But he sought to draw our attention to the orders which we had made, yes, and the fact, yes, that he hasn't moved the application. Yes. No, Mr. Gotamba. Has the application been moved?
No. My lord,
it's a court of, he must formally move the application. It has not been.
My lord, he hasn't formally moved it, but I was also informally drawing the court's attention to the court's own rule that says that when there is an application pending, you ought to comply with the orders of the court. The fact that you have an application pending doesn't mean that you disobey the orders of the court.
Please.
And that obeisance.
Didn't you hear me drawing the attention of counsel to the fact that there was a pending order? Yeah. In some cases, addresses may even be waived. Yes. The court can make an order that lodge your respective written addresses on or before this. A party may decide to waive the address and allow the court to proceed to give a judgment. Yes, so don't belabor this point.
Well,
that when we come on Monday and take the application, yes, we will decide to fix a date for judgment. Period.
I'm grateful.
Please, do you want to formally move the application?
No, my lord, I will abide by your previous indication that will come on Monday.
Yes. No, this application is fixed for today.
The Monday matter is different.
It's different.
My lord, I knew that when I said that the matter of the review has been heard. And I drew attention to the fact that in terms of what remains, it has to do with the orders that your lordships gave. I drew attention to that. And I drew attention also to the fact that Order 36, Rule 4.3 makes certain provisions which are not quite consistent with what your lordship decided. Now, my lords, I took the indication that you gave to be that we would come on Monday in respect of that, because we don't want to have to keep repeating these issues, because frankly, frankly, I mean, the issue, there's a motion for stay in respect of that as well. And in fact, we assume that the motion for stay will be heard first. But your lordships had a review. We are not raising an issue about that. I was just drawing your lordship's attention to Order 36, Rule 4.3, and your lordship explained that in the light of case management, you have done certain things and so on and so forth. But my lord, I mean, you then gave the indication that we should come on Monday, and I believe that it would be appropriate, therefore, for your lordships to record that indication, and we come on Monday and proceed appropriately.
We have to take the motion. It's a pending application which has been filed. We don't have copies, but the registrar has informed us. Yes. Yeah, I hear you have been giving copies. Yeah. Sorry. The pending one. This one. If it is the case that you have filed another motion for stay, and this one is already on record, either it is leave is sought and it should be struck out as withdrawn, so that we wait for the Monday application and take it. We cannot certainly impose so much on you.
The point of my making reference to Order 36, Rule 4.3 is that we do not want to have to bring another formal application in respect of that matter, because we think that in terms of what one of your lordships has described as judicial economy, we think that if we bring this matter up before you in the context of this motion, your lordships may wish to advert their minds to it and give directions appropriately, and that can still be done on Monday after your lordships have had a chance. But your lordship gave the preliminary indication that even though Order 36, Rule 4.3 is very clear about the order of addresses when they have elected not to adduce evidence, very clear about that. Even despite that, your lordships have taken a different course, and you have indicated that that different course is on account of the way that you handle election petitions and so on. So sometimes we go by CI 47, sometimes we don't go by CI 47, and it becomes extremely difficult for anybody in these circumstances to know, in advance what the court is going to do. So my suggestion, if I may, and your lordships can determine the matter within your discretion. I mean, my understanding, not my suggestion, my understanding of what your lordship indicated was that we come back on Monday, and as at that time, depending on whether we are proceeding with the motion for stay first or not, we may be in a position to seek leave for the current motion which relates to be struck out as moot, and then we proceed in accordance with that. But I thought that I was duty bound to bring your lordship's attention to a matter which we can raise in another way, if your lordships want us to raise it, regarding the non-compliance with Order 36, Rule 4.3.
I see that, but it has even been overtaken by events. They have even filed DS first. Well, yes, so please, I think we don't have to maybe go at length to address this, because they have filed it.
Well, they have filed. Well, we haven't been served anyway, but in any case, we don't need to be served, because the point I'm making is that they brought up Order 36, Rule 4.3.
For another matter.
Well, they brought it up.
Yes, in respect of another application.
Well, how can my lord say it's in respect of another?
No,
they brought the order. My lords, they brought up the order to your court, seeking to have it applied in these proceedings.
In respect of closing addresses.
In the course of the proceeding,
but not in respect of closing addresses.
My lords, with the greatest respect, in respect of everything, because Order 36, Rule 4.3, which they brought up, is supposed to guide the conduct of the proceedings after they elect not to adduce evidence. That's what that order provides. After they elect not to do evidence, so and so and so is supposed to happen, including the addresses. So, my lords, when they raise that matter up, that's when we did start raising the issues of what that order really is about. And in the meantime, your lordships had given certain directions about the filing, which were inconsistent with Order 36, Rule 4.3, and I was respectfully drawing your lordships' attention to that. And if we come on Monday and it is appropriate, you can withdraw that and pursue the other motion for stay and the application for leave. But, my lords, if you want me also to move the motion, I'm prepared to move it and draw your attention formally on record to what I've drawn to your lordship's attention.
My lords, I was trying to point out to the court that this particular motion on notice for stay of proceedings is filed pending the application for review that has just been determined. So, my lords, it's either my learned friend withdraws the motion or is struck out because it's moot.
My lords, I completely associate myself with counsel for first respondent, and to say that I do not know what this current application is staying. It cannot be staying the application for review, which has been settled. So it has no purpose and ought to be struck out if it's not ready to withdraw it as struck out.
My lords, I've given my indication. I'm abiding by your earlier statement about Monday, and if your lordships wish to decide otherwise, I leave it to your lordships.
So you see, it's your application which is on record. We do not want to take any step till Monday. So if I understood them, they are telling us that the motion is moot. Yes, and striking it off the record doesn't occasion any injury to anybody. So that is their submission. So that we come on Monday, take the application for stay, and then the review which has been filed.
My lord, I specifically took the opportunity to draw your lordship's attention to what I believe is still relevant in the motion. That is that we did not file. We filed this motion ahead of the deadline that your lordship has set for the filing of written addresses, because, my lords, we wanted the matter of that deadline for written addresses to be dealt with in the context of that motion. That's why that motion has still relevance. And I respectfully drew your lordship's attention to the fact that as we speak, your orders, indeed, which are pending, say that there should be simultaneous, in spite of Order 36, Rule 4.3. And I drew your lordship's attention to that because I think that it is important that we all, try to assist to arrive at the appropriate and just processes that will lead to legitimate conclusions by this court. And so, as far as I'm concerned, your indication about Monday is what I thought was appropriate, because if on Monday you hear the other application, and depending on how you address the issue of addresses being filed, because we have not filed an address. That address has not been filed because of the pendency of the stay application. And we did not wish to take a step that will be prejudicial to our own interests. Because in terms of the addresses, if our review application were granted, we assume that there are no predetermined outcomes. And therefore, if there is no predetermined outcome of a review application, the review application, if it went into in our favor, would lead to a witness being, having to testify. That would be the result of the review application. So if we withhold filing a review, a written address, it's not out of disrespect to the court's order, but out of a respect to the fact that there's a pending review which can affect the filing of the address. Because if your lordships were to grant the review, that would mean that a witness would have to come and testify if your lordships were to grant that. And as I said, we assume that there are no predetermined outcomes.
My lords, I have two submissions to make to the court. The first is that the application for stay, as we said, was based on the review application which has been determined. And my lords, we all know that you can't put something on nothing. So once the review application is determined, no matter the degree of legal eloquence, that application is dead. That's my first point. My second point is that the order 36 rule 4, which he refers to, has a very important qualification. It says 641, unless the judge before whom an action is tried gives direction as to the party to begin and the order of speeches. My lords, this court has given directions as to the order of speeches. So counsel cannot seek to rely on that clause which gives the court the power to give directions otherwise than as stated in the rules. So this argument is totally misconceived once again and should not be given any consideration by this honorable court. The application, therefore, if counsel is not willing to withdraw it, should be struck out by this court. And consequently, the court has to decide what it intends to do with this defiance of its orders by the petitioner. I think
Mr. Gutampa, you are telling us what to do?
No, I'm not telling you. My lords, far from that. I'm not one of those lawyers who think that they know better than the court.
Order, please.
by court. This court is the opinion that the application for stay of proceedings was filed to stay proceedings before the hearing of the motion for review application. We think that as the motion for review has been determined by the full bench, the application for stay of proceedings is moot and same is struck out. The petition is adjourned to Monday, the 22nd of February 2021 at 9:30 a.m. for the pending applications to be taken.
We are grateful to the court.
My lords, we are most grateful.
All rise.
And that's the end of today's court hearing, the election petition updates. There were two applications before the court. One was argued out with a ruling. That's the review application, which was dismissed. The other one, the stay of proceedings application. Now, what has happened to that application is that the court says that application is moot because that was pending the application for review, which it has already dealt with. The little holdup was whether or not Mr. Chachi Chikata was going to withdraw that application or the court will strike it out. He wanted the court's direction. He wanted the court to take a lead in this instance. And the Chief Justice just announced that the stay of proceedings application has been struck out. And so one application determined today, which is the review application, which the full bench unanimously dismissed that application. We'll get some brief understanding before we wrap up this session with Samson Ladia Yenini. But of course, as always, the two sides would address the media, the petitioner and the second respondent. We will wait for that. It's been said, and one of the clarifications that we would seek is the fact that when there is an application before the court, you don't disobey an order by the court. The parties were expected to file their written addresses by the date that was given Wednesday. And we know that the petitioner has not yet done that. Something will help us with an understanding because the Chief Justice didn't give a clear direction in terms of a deadline for the petitioner. Maybe there's something that we missed. Something will help us with a clarification on that. But the sitting has been adjourned to Monday at 9:30 because there is another application, another review. This will be the third one that the court will hear on Monday. And this is the 16th February ruling. And this has to do with the application to reopen the petitioner's case. Remember that on Tuesday, that ruling came out. And here's what the court said in its ruling that the petitioner in the application had not given an inkling of the new or fresh evidence he wants to bring to the fore through the chairperson of the first respondent, and how that evidence would assist this court to do justice in the matters under consideration in this petition. Neither has he disclosed how that evidence would advance the course of his petition. And for this reason, they found no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness, and how that evidence is going to help the court in resolving the dispute before it. So it refused the application and also subsequently dismissed same. That is what the petitioner is seeking a review for, and that hearing will be on Monday. Samson Lali Ayeni joins us on the phone. Samson, just some bit of clarity on the written addresses. The court was not upset at the fact that the petitioner had not filed the written addresses as the court had directed. But what does that mean? Is there a deadline for them to submit that or file that written address?
There was a deadline given, right?
Maybe I missed that. I'm not sure, because there was no comments necessarily on that.
There was a deadline giving all the parties to file their written addresses simultaneously.
That was on Wednesday yesterday.
That deadline was supposed to be on the 15th, or is it? I don't recall exactly.
No, so that was 17th, Wednesday yesterday. Mm-hmm.
Yeah, and therefore they were to file it, and then the next day they were to return in court. They were to highlight portions of those addresses to the court. Once that deadline has not been met, and you heard Chacho say that they didn't want to take any fresh steps to compromise their application that was pending, because they are filed for a stay of proceedings pending the determination of the review application. If they had done anything else, they would be deemed to have compromised whatever they were doing. But as has been pointed out by Martin Table to you earlier, while that used to be the case, the court had changed that position, that if you have something pending, it is not a reason to disobey an order that you have to comply with. So you go ahead and comply with, and when you comply with that order, you would not have compromised what you were seeking to do. But originally, that used to be the position of the law, and it was a sound position of the law, that once you are challenging something, you are not found to have complied with something that you are challenging already, and filing the address would have meant an admission that you don't actually need the you don't actually need the witness that you are trying to bring in for them to give their evidence before you actually, do your address. So now, once they have not complied with it, they must ask for leave of the court. They must ask for leave of the court, and the court will grant it. It will not deny them the leave.
Okay.
It will ask them for leave they will ask for leave, and the court will give them a grant to file it.
All right, Samson, thank you very much. We're crossing over to the Supreme Court.
The main reason why we're in court today, as you heard and watched for yourselves, today, counsel for the petitioner moved an application for review of the court's decision on the objection which was raised when counsel for the first respondent decided to close their case without calling Mrs. Jean Adukwe-Mensah to testify, contrary to what she herself had indicated in several dispositions on oath before the court. Now, you would recall that in the court's decision on that objection, the indicated that a party cannot be compelled to adduce evidence, and so they dismissed the objection raised by counsel for the petitioner. And so today's review application sought to demonstrate to the court that that decision was based on fundamental errors of law, which has occasioned a miscarriage of justice to the petitioner. And the grounds that counsel for the petitioner the decision of the Supreme Court on that matter was per incurium. Per incurium basically means that it was without regard for the law. And what law are we talking about? Section 26 of the Evidence Act. Because what counsel basically said was that, yes, we know that a party cannot be compelled to give evidence. That is trite legal learning, and we are all very familiar with that. But we are also aware of Section 26 of the Evidence Act, which establishes the principle of estoppel, that even though you are entitled to do something, you can be entitled to do something in law. But if by your own actions or conduct you make another person believe that you will not do that which you are entitled to do under the law, then the law must not allow you to resile from that position. The law must not allow you to change your position. That is what is meant by estoppel. And so, counsel for the petitioner's argument is basically that, yes, the first respondent is entitled not to adduce evidence like any other party in court, but because Mrs. Gina Dukwe-Mensah, as a witness, had already elected to give evidence per several depositions in her affidavits before the court. And when we talk about an affidavit, we are talking about depositions under oath, that the court should not allow us to ask her questions through interrogatories because she will be available for cross-examination. We were of the opinion that on the basis of Section 26 of the Evidence Act, she was stopped from resiling from that, and that granting her the right to change her mind will amount to her playing tricks on the court, because you cannot say in one breath that I'll be available for cross-examination to answer certain questions, and then when it is time for cross-examination, say that, oh, I'm no longer willing to do so. And so the court should not allow her to do so. And counsel today in the application for review argued that the court's ruling did not comply with Section 26 of the Evidence Act. In fact, the ruling made no reference whatsoever to Section 26 of the Evidence Act. And so, in our opinion, that was a fundamental error of law, and that renders the decision per incurium and should be reviewed. Again, counsel argued that the courts in another matter, the Sumaila Bilbo case, had established clearly that even though a party is entitled to give evidence in support of his or her case or not to give evidence, in that case, the defendant, the first defendant, elected not to give evidence, but the court compelled the defendant to enter the box and give evidence. Why? Because the court said that it is in the interest of justice that the first defendant, having given certain depositions in certain affidavits, enter the box to give evidence. And so, by parity of reason, counsel for the petitioner argued that that same principle should be applied to this case, because the interest of justice demands that G. Mensah, having intimated to the court that she will be available for cross-examination to answer certain questions that are pertinent and germane to the issues before the court, should not be allowed to resile from that, but she should be bound by her own depositions. Again, counsel drew the court's attention to another fundamental error of law they made in their ruling on his objection. You realize that in the ruling, the court relied on Order 38, Rule 3E1 of CI 47 as amended by CI 87. And counsel's position, which is the position of the petitioner, is that that order that was more or less the basis of the court's ruling was not part of the submissions of counsel for the first respondent and the second respondent. In arguing or in opposing counsel for the petitioner's objection, they never made reference to that order. That order was rather suggested by the bench, specifically Justice Apau, because they came under Order 36, Rule 4.3 and Order 38, Rule 3E5. They did not come under Order 38, Rule 3E1. And so why would the court base its decision on a rule that the respondents never came and it never invoked? Then counsel for the petitioner also addressed this issue about, the petitioner keeps on saying that Madam G. Mensah has a duty, a constitutional duty to the people of this country to testify and to provide answers to certain pertinent questions that are germane to the issues before the court. And why are we saying so? Because the fact that she is EC chairperson doesn't mean that different set of rules should be applied to her. Counsel for the petitioner today argued that we are not asking the court to subject Madam G. Mensah to a different standard. We are asking the court to subject her to the very rules that every other person is subjected to. Including 26. And that rule is simple. You, G. Mensah, you were the returning officer for the 2020 presidential election. You conducted the election and declared the results of same. In your declaration, you stated that the total valid votes for the election was 30,434,574. And then you stated that candidate Akufo-Addo got 6,730,413, constituting 51.5%. We took our calculators and did the same calculation, and we saw that if you divide 6,730,413 by 13,434,574, you don't get 51.595 as we gave him. You rather get 50.089. And so why did you increase the votes of the second respondent, candidate Akufo-Addo, unjustifiably, when your own figures don't support that? And in your own declaration, after you made this flawed, you gave him this undeserved petition, you proceeded to say that even though you did not have the results for Techiman South constituency, you were not going to wait for that, because even if all the votes in Techiman South were added to that of the second candidate Mahama, candidate Akufo-Addo will still cross the more than 50% threshold. And we took our calculators again and did the calculation. The total votes in Techiman South are 128,018 votes. If you add that to the total valid votes she declared, 13,434,574, you get 13,562,592. And if you divide candidate Akufo-Addo's votes, 6,730,413 by that figure, and you multiply it by 100, you get 49.625. That is the figure candidate Akufo-Addo got per G. Mensah's own declaration, per her own figures. And so if, subsequent to that declaration, you claim to have made a mistake, in fact, so flawed was that declaration that if you added all the percentages given to the 12 candidates, you get 100.3%, a clear mathematical impossibility. Then this woman comes to tell the nation that I've made a mistake. And in rectifying that mistake, an unsigned press release is issued. An unsigned press release, therefore, in our opinion, cannot be a declaration or a rectification of the alleged error. And even in that unsigned press release, different figures were issued or put out, 14, 433, 533, different figures. And contrary to what she herself has stated in that unsigned press release, that she was only introducing a new figure for total valid votes, she actually massaged or adjusted the votes of the candidate, reduced that of Mahama by 1,707, and that of candidate Akufo-Addo was increased by 174. Subsequent to that, she came to court. All Ghanaians thought that she was going to rely on her so-called correction, only to abandon the so-called correction she had told the nation through that unsigned press release. And then came to court with another figure, 13,121,111. and then abandoned the votes she gave candidate Mahama and candidate Akufo-Addo on the 10th, and went back to the votes she declared on the 9th. And then you go on their website, you see different set of figures. You check the 16 regional coalition fees, you see different set of figures. And so we are saying that her own conduct, which is the subject of this petition, makes it imperative for her to testify and provide answers to all these issues, so that the court and Ghanaians at large will know the truth in this matter, and so that justice will be done. And so we are not saying that different set of rules should be applied to her. We are saying that as a public officer, she should be held to account, particularly when she herself had already intimated to the court that she will be available for cross-examination to provide answers to some of these questions. And then last but one, Council raised a very important issue that we want to stress, the issue of fair hearing. That all these applications we are bringing before the courts, at the heart of these applications is the issue of fair hearing for the petitioner, and by extension the people of Ghana, because the petitioner is doing this for and on behalf of all of us. And that having relied on that representation by Madam G. Mensah, and having closed our case based on that representation, we will be denied fair hearing if she is not held to her own representations conclusively under Section 26, because under Section 26 and 24 of the Evidence Act, she has put herself under a conclusive presumption that she will testify. And we think that it will not be fair. The petitioner will not have fair hearing if this is denied. And then finally, ladies and gentlemen, counsel argued that
the female judge, the breach.
The court itself, when counsel was arguing, the objection he had raised, made a point that, counsel, are you saying that she is stopped from changing her mind? I'm sure you all remember one of the justices of the bench asking lawyer Chachuchi Kata then that, so can't she change her mind? It was all in reference to the issue of estoppel. So why the court did not make reference to that and deal with that in this ruling, for us, is a grave, if you like, violation of the law. Now, in the court's decision on the matter, they simply said that they disagree with us because we have not shown that these fundamental errors of law have occasioned any miscarriage of justice to the petitioner. That is why we vehemently disagree with the court. We respectfully but vehemently disagree with the court, because these applications are not being brought for nothing. We believe that in line with Article 19, Clause 13 of the 1992 Constitution and Section 26 of the Evidence Act, G. Mensah must be made to testify based on her own election and to answer questions that are germane to the issues before the court. And that refusing that would deny the petition of fair hearing. What else do we need to prove before the court will know that their non-compliance with Section 26 respectfully has occasioned a miscarriage of justice to the petitioner? Because that is without saying, it is a given that their non-compliance has occasioned a miscarriage of justice to us. So what we want to tell Ghanaians who are watching this briefing, particularly the over 6 million Ghanaians who voted for His Excellency John Dramani Mahama, is that some of these decisions are not going in our favor. And there is a tendency for some of you to be crestfallen and sad. But we are standing here as leaders who have the authority of His Excellency John Dramani Mahama to tell you that don't give up and don't give in. Chin up, square up your shoulders, because no matter how this court decision will go, no matter how it will go, Ghanaians, all of us are discerning. The world is watching, and we will all know the truth for ourselves. Thank you very much. If you have any questions, you can ask.
My name is Kwekwa Sante, JoyNews. Among other things, you've cited some of the things the court said, for which reason. Okay, so among the points you've raised in the ruling of the court also says and agrees with the respondents that your review application was simply to re-argue the point that you've made
maybe you heard that from counsel for the respondents, but that definitely did not come from the bench.
Right. Let me go to the ending of what happened in court today when Mr. Shishikata wanted to, in terms of the stay of proceeding, the court has struck out the application as moot because the application was predicated on the review that has just been disposed of.
Yeah.
And so if you are insisting that it moves to Monday, then...
And counsel for the petitioner didn't disagree with that position. Just that a certain indication had been given to him by the bench that we should come back on Monday. Because whether or not you withdraw that voluntarily will have a bearing on pending orders of the courts. And so we all know that since the review application has been heard and determined, it rendered that application for stay moot. That is right, we all know that. But the most important thing is that there is another application for review in connection with the ruling of the court on our application for leave to reopen our case and to subpoena Mrs. Jim Mensah. That application will be heard by the court on Monday, and there is a stay of proceedings attached to that as well. So that will be heard on Monday. And so we are exploring all options, and we are fighting this case to the very end. And we are assuring all our supporters and all Ghanaians to be patient. Yeah,
two quick questions. One on the call it admonition, the encouragement given to supporters across the country, the note on which you ended the main address. How much disaffection or how dissatisfied are your supporters across the country in what you have described as the case not going in your favor? And is that in any way influencing the next steps we are seeing on Monday, irrespective of how the Monday application...
I didn't get your question. Are you saying that what?
How dissatisfied are your supporters across the country? That dissatisfaction, will it in any way inform your next moves from Monday, irrespective of how the application goes on Monday? The second quick one. There are reports in sections of the media of a contempt case against the lead spokesperson for the team. Indeed, he's the one who usually addresses us. Today, he's not here. I was hoping to ask him whether indeed that he's been served that contempt and charges, and when he's responding to them. Is that the reason he's not here?
Okay, thank you very much. First of all, we are in no position to anticipate the decision of the court on the applications pending before it, which will be heard on Monday. And we are in no position to anticipate their decision on this matter. What we have said is that no matter how it goes, Ghanaians can discern the truth for themselves, and we will all know the truth, and the truth will set us free. And so we are determined that regardless of how many interlocutory applications, are determined in a certain way, we are not giving up, we are not giving in, and we are doing this for God and country. We are doing this on behalf of the over 30 million Ghanaians who have promulgated for themselves a constitution which states that one can only become a president only when that person gets more than 50% of the total valid votes in any election. Candidate Akufo-Addo did not get more than 50% of the total valid votes per CI 135 and the declaration of the returning officer. And therefore, we will challenge it, and go the full haul and ensure that justice is done. Now, to your second question. First of all, Dr. Ayine is not in court today and is not with us here because he lost a friend and he had to go for the funeral. That is why lawyer Tony Leta is also not in court. So he's not in court not because of any alleged contempt proceeding that has been brought against him. Number two, officially, we are also not aware of any contempt proceedings that has been brought against him. We've seen a publication by Asase Radio which makes reference to no process. And we don't know how they got that information. So we will wait and get confirmation of that before we can make our position on that known. But be rest assured that Dr. Ayine is a senior member of the bar. He will not deliberately disparage the court or seek to scandalize the court in any way. And he is capable of explaining these issues in a way that the justices of the Supreme Court and Ghanaians at large will appreciate when that time comes. Or if that time comes, let me put it that way. But the party has issued a statement on this issue. Not necessarily the committal for contempt proceedings and all that, but statements that have been made by spokespersons of the second respondent, candidate Akufo-Addo. And here we are referring to people like Kojo Oponkroma, Nana B, who at this very platform and on different platforms have sought to deliberately instigate and incite the court against Dr. Ayine. We want to condemn in no uncertain term that shameful conduct of our colleagues, because as lawyers, that attitude is completely shameful and unacceptable. They know that Dr. Ayine did not say what they have said he said, and they know that the interpretations they are putting on what he has said are slanted and false, and they know that even if any of us here are in breach of any law or stand the possibility of being held liable for contempt, it is absolutely wrong for colleague lawyers to be the ones fanning the flames. We're all in this country during the 2013 election petition. We saw people from the NDC and NPP be cited for contempt, and you saw the unity at the bar between all the parties in defense of these people. When my own brother Samia Wuku was cited for contempt, you saw how lawyers for John Mahama at the time and the NDC defended him. And I believe the other side also did the same thing for my own brother and colleague Kweku Buai. Why are lawyers like Kojo Oponkroma, Nana B, who by the way are juniors by far to Dr. Ayine, trying to instigate the court and incite the court against him on the basis of things he has not said, and when they have made worse statements than that are even more contemptuous? Because my brother, the court, I believe, has been very liberal in how it has conducted these proceedings, and even where senior lawyers who are on record have heard, the court has been very liberal in giving them, cautioning them here and there and all that. You saw them do that to Francis Davies and other Frank Davies and other senior lawyers. Because if the broad rules of contempt are to be applied strictly, then the first culprit will be Kojo Oponkroma, because nobody has prejudiced this matter, which is sub judice, than him. How many times hasn't he stood here to dismiss the case of the petitioner? How many times haven't you heard Nanabi say that petition, I told you, the petition is baseless? The petitioner has not discharged his evidential burden or the burden of proof. Are they justices of the Supreme Court? Are they clothed with power to pronounce definite conclusions on matters that are sub judice? That is also contempt. Yet nobody has called on the court to cite them for contempt. So they should stop this shameful conduct. And finally, let me also raise this point, which is tied to what we are talking about. The disrespect from spokespersons of the second respondent for lawyer for the petitioner, in the course of these proceedings, for us is very unacceptable. You hear them stand here and describe things that counsel for the petitioner has said as English and grammar. Lawyer Chachuchi Katai was just speaking English and not law. You don't do that. We are not trained to say things like that about our seniors at the bar.
Have we said that?
All these people are juniors by far to the people they are trying to ridicule. When we come and stand here, we don't ridicule the likes of Senior Kutu Ampao and Justin and Manuva. We all see how they struggle on their feet, yet we don't come here to mock or ridicule anybody. You understand? So, why do you come and stand here and talk down on somebody that you may never be able to even come close to what they have attained or achieved in life. I'm not sure that even President Akufo-Addo would disrespect Lawyer Chetuchi Carter. So let us uphold the ethics that we have been taught as lawyers and give respect to whom respect is due, and stop instigating the courts against seniors, stop ridiculing seniors. We are not supposed to do that. We should know better.
So, I'm sorry, because of time, we may have to regulate this. Yes, but there was a bit of my question about disaffection amongst your followers that you have not addressed.
There is no disaffection. We are leaders and we are providing leadership, and we are telling them not to give up, because we are not giving up. The truth at the end of the day will become clear to everybody, no matter how this decision goes. That is the assurance we are giving them. Thank you.
Asama and a seal court, ne tofa bomo a boy in 97.
And you're still watching our continuous coverage of the election petition hearing. You just heard Sami Jemfi, who is a communications officer, national communications officer for the NDC, whose flag bearer, by the way, is the petitioner, mentioning a few things. Well, he indicates, by the way, that what they're seeking to do is to get fair hearing for the petitioner. He says that fair hearing for the petitioner will be denied if Madam Jean Mensah, who is the chairperson of the first respondent, is not allowed to testify or is not made to testify because she is a public officer and had given and had put herself under what he called a conclusive presumption that she will testify. He also says that if that is not done, then there will be a grave violation of the law. He says there will be miscarriage of justice to the petitioner if the applications, some of the applications that they put in, especially for the review, are not upheld. He says that Madam Jean Mensah must be made to testify so she can answer some of the questions that they have. And he's also he called on the supporters of the party not to give up, to walk with their chins up, and answered a few questions that I will just go through briefly. He says that, well, if you have been following this, and as you may be well aware, there is an application to subpoena Jean Mensah that will be held on Monday. But before that, he's assuring their followers to be patient. Now, there was a question about what their next move will be after Monday, and he said that, well, this is work they're doing for God and country, as he put it, and that they will challenge the process until to the full haul. They will challenge it with all the options available to them. There was also a question about contempt as far as Dr. Ayene is concerned, that there have been rumors of contempt processes being filed against him. He said that Dr. Dominic Ayene is not here today, and he would ordinarily do the press briefing after the court hearing. He says Dr. Dominic Ayene is not around because he had lost a friend and had to go. The same applies to Dr. Tony Lita as well, who was not there at the time. He says this is not because their absence is not because of any alleged contempt proceedings. He says also that the NDC or the people in this particular suit for the petitioner have not seen any official contempt filings as yet. But they have seen a report by an Accra-based radio station, but that until they find or until they are served officially, they will hold on to their official position on that matter. But he went on to address the issue, and by doing that, he said that Dr. Dominic Ayene is a senior member of the bar and will not in any way scandalize the court. He says that Dr. Dominic Ayene as well is capable of explaining himself if that becomes necessary. He also indicated that the NDC, by the way, has issued a statement, and in that particular statement, they address concerns that they have about Kojo Oppong-Nkrumah, who is a spokesperson for the second respondent's legal team, that's President Akufo-Addo's team, as well as Nana B, who usually speaks, who usually translates what they say in the local language, about deliberately instigating the bench. Their statement is about what they call deliberate instigation of the bench by these two individuals, which they describe as completely shameful and unacceptable. He says that even if what Dr. Ayene, according to Kojo Nkrumah and Nana B, are saying is true, it would be wrong for Kojo Nkrumah and Nana B to go out there to incite the bench, as they put it. He goes on to talk about the fact that they are juniors by far to Dr. Dominic Ayene, and that they shouldn't do that. They talk about disrespect of the councils. But we can go back to the courts right now.
I will simplify what occurred in court today. The court, on hearing arguments, held as follows: that the review jurisdiction of the court had not been properly invoked, and as such, the application for review was dismissed. The review jurisdiction of the courts is not to be granted sparingly, especially when the decision of the court is a unanimous one, that is 7-0. The scales will most unlikely tilt in your favor when you go for a review, especially when the ruling is grounded firmly in the law. The mere repetition of arguments does not metamorphose your arguments into a correct one. So that is what we must take note of as friends of the media. Secondly, the stay of proceedings was struck out as moot. This is based on the assertion that the stay of proceedings, which is an application to put a halt to proceedings, was pending the review, but then the review had been already determined, and as such there was no need for the stay of proceedings to be heard, and as such the court gladly struck out this application. With regards to what will happen on Monday, the court held that based on another application by the petitioner, the court will then hear these applications and proceed to give a firm date for judgment. However, it is instructive to note that an order of court cannot be halted by an application for stay of proceedings, nor an application for review. So this repeated non-compliance with the orders of the court is something that is unacceptable behavior, even for any member of the bench or any court. This is unacceptable, much more the apex court of the land, and this should not be countenanced. When we proceed to the matters let's proceed to what my colleagues on the other side have stated when they came to address the media. Sometimes there are usually some misconceptions that need to be clarified. With this argument of estoppel that keeps on being bandied about, the court firmly dismissed this argument and stated that it does not apply in these circumstances. The court further held that the strength of your case does not depend on the weakness of your opponent's case, and as such, the petitioner keeps on coming to us stating that Nana Addo Dankwa Akufo-Addo did not obtain more than 50% of total valid votes cast. Where are your figures? Show us your figures. We are not getting anything from the petitioner nor his witnesses. And as such, we are still lost as to why we are in court. We also feel that the petitioner who brought us to court should actually be in a hurry to file his closing addresses. But there has been a consistent delay in this process, and we do not understand why. We have filed ours. And even when the petitioner's lawyer was on his feet today, he mentioned the fact that the Order 36 lays down the procedure for order of speeches. So in actual fact, they were to file their closing addresses, then we file our closing addresses. But the court has the power, per Order 36, Rule 1, to decide and order how this order of speeches should take place. And as such, the court, rightly so, ordered that both parties file their written addresses simultaneously, and that is firmly grounded in law. I do not hold brief for the Supreme Court, but it is instructive to note that the sanctity of the court is something that must be upheld and religiously guarded by us as lawyers, by litigants, and indeed the entire citizenry of Ghana. And especially when you are before the apex court of the land. This is our final resort when an aggrieved party brings a matter to court, and as such, this sanctity must be jealously guarded. Justice is not a concept that is born out of nothing. It is firmly grounded and must be prescribed within the law, within statutes and decided cases. So when there is the bandying around of the need to do justice, it should be within the ambit of the law. And that is very important for us to note. Litigation cannot go on in perpetuity. This matter must come to an end one way or the other. Just because of the repetition of arguments and the consistent review, the consistent application for review, does not mean that this matter will not come to an end. It has to come to an end, and the orders of the court were specific for the filing of closing addresses. We are happy that the court expressly stated that on Monday it will give a date for judgment. So as we, as Ghanaians, prepare to come to the end of this momentous election petition, we would call on all parties to gladly accept any judgment, the judgment that comes out of this matter, be it in their favor or not. And I would like to remind all of us, in 2013, His Excellency Nana Addo Dankwa Akufo-Addo instituted an election petition in the Supreme Court. When the judgment was given, he did not agree with the judgment, but he graciously accepted the judgment of the court, and he stated categorically that he does not agree with same. We are hoping that whatever the verdict, whatever the judgment that comes out of this matter, that any party that is aggrieved will gladly and graciously, as our client did, in whom we are so proud that he did same, that this will take place when the judgment is delivered finally. I would like to end on a lighter note to state that this petition reminds me of my favorite author, Chinua Achebe, in his book Things Fall Apart. And what he says is that indeed the petition cannot hold. Thank you. We'll now invite some questions. Okay.